Welcome, everyone, to the PCI Practical Matters podcast. Today, we're talking about the top 10 tips and traps for bid protest. This is part 3. We're joined once again by Cy Alba. Take it away, Cy.
Thank you again, and welcome everybody. My name is Cy Alba. I'm partner of the law firm at Polaro Mazza, and we're going to talk about our final piece on bid protest tips and tricks, like we just said. Starting off, this is going to get into some of the more nitty gritty. We talk through like where to file, when you have to file, some of the nuances on when you file to get the stay, and all of that in the prior sessions. Now we're going to talk about some particular circumstances when you see yourself stuck with something and some of the traps that come up there. First is, what about task order protests? So your protest contracts, which are these standalone contracts, whether it's an IDIQ vehicle that has multiple awards or it's one that has a single award. But what about task orders? So that's where there's some sort of umbrella contract that already exists that you've been awarded, and the government is issuing task orders under that. And those task orders, a lot of times, if it's a best-in-class contract or some sort of IDIQ contract, those task orders will have entire competitions that are it's almost just like a whole new contract, right? Where you're preparing your proposal, you're filing them, you're competing with a bunch of other companies, and it's very similar. However, there are special rules dealing with task orders that don't apply at the general contract level. So when you're dealing with task order protests on an IDIQ contract that is not a GSA schedule, in that scenario, there is something called the FASA bar. Congress, in its infinite wisdom, decided to limit your ability to hold the government accountable when you want to challenge their award determinations under task order. First, if it is a civilian agency, you cannot protest a task order valued at less than $10 million. If it's a DoD agency, you cannot protest a task order valued at under $25 million. When those task orders are come out, if it's a $9.9 million task order and it's a civilian order, you cannot protest. You can send a letter to the ombudsman at the agency and complain and stomp your feet or scream to the heavens, but you cannot file a protest at GAO or at the Court of Federal Claims because there is a statutory bar. Further, even if you are above those thresholds, you cannot file a protest with the Court of Federal Claims, and arguably you can't file it with the agency. This legislation gave exclusive jurisdiction to GAO to hear task order protests. So if you have a $15 million civilian task order, you can protest to the GAO, but even though it's above 10 million, you can't go to the Court of Federal Claims and you can't go to the agency generally. Now, the exception to all of these rules is that if you're challenging the scope of an order, saying that task order is outside the scope of that IDIQ contract, that you can file. You are allowed to file that even if the task order is below the $10 million or the $25 million threshold, because that particular issue falls outside of the scope of the FASA bar. Similarly, if you're on a GSA schedule contract, a multiple award schedule, a federal supply schedule, call it what you will, under that specific schedule, that doesn't mean a GSA IDIQ, right? Like STARS 3 or one of those, right? That does not count. That is still subject to the FASA bar we talked about. It's only the federal supply schedule task orders that are exempted. If it's one of those task orders, you can file at GAO with the agency or at the Court of Federal Claims. There is no restriction. It could be a $1 task order. It could be a $0 task order. You could still file a protest and you can choose where to go because GSA schedules and the task orders under GSA schedules are not included in this bar that we're talking about. Now, when you're looking at something, like how do I know if it's above or below the 10 million for civilian or the 25 million for the court? Well, or the DoD. When you're looking at that sort of issue, you're looking at generally, well, what was the awarded contract, or what was the government estimate if it's a pre-award issue, right? Like what exactly is that number? If the awarded contract is above that number, you can generally protest. Again, it has to go to GAO if it's a standard IDIQ task order. Also, there's a question that comes up, and this has come up recently in some of the GAO cases. How do I know which one applies? What do you mean when you say civilian or DoD task order? Is it the agency issuing the task order, or is it the contract under which the task order is issued? Well, the GAO has answered that question, and they have said, at least the current case law, is that it's the nature of the IDIQ contract that matters. So if you're dealing with STARS 3, okay, let's say the Air Force issues a task order on the STARS 3 vehicle. The Air Force is obviously a DoD agency. Let's say that task order was, $30 million. That task order was under STARS 3, which is the GSA IDIQ. In that circumstance, the cap on that would be the $10 million cap or threshold to file a protest because it's under a GSA contract. If you're dealing with something that's a DoD schedule, like Seaport or something like that, if you're dealing with that kind of contract, that is a DoD contract. So if DHS puts out a task order on the Seaport contract, and that task order is $15 million, that is a civilian agency issuing a task order under a DoD vehicle, and it's $15 million. So while it's above the $10 million threshold that applies to civilian contracts, task orders, it is not above the $25 million threshold for DoD. And because Seaport is a DoD vehicle, then you are prohibited from filing that protest because it's not above the $25 million bar. So it's very important to look at that and to understand these thresholds before you get everybody spun up. It's also very important immediately when you're talking to your counsel, if you're working with a lawyer and you're talking to them, the first thing you need to tell them is this a task order? Yes or no? And if it is a task order, where? Is it a GSA task order? Is it a DoD IDIQ? Is it a civilian IDIQ? Where was that task order issued? And we need to know what that number is and where it was issued, because that's going to tell us whether we can protest, or if we are going to protest, where we have to protest. All of that is very important. That also triggers all the timeliness rules as to where you're going to go and how you're going to do it that we talked about earlier in these sessions. So it's very, 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 very important that you are paying attention to these rules and that you understand where these things are being filed, how they're being filed. Because, again, if it's a task order, it has to go to GAO. It cannot go to the Court of Federal Claims unless it's a task order under a federal supply schedule, GSA schedule. And even if you can file a GAO, it has to be a task order valued above the $10 million threshold for civilian IDIQs or above the $25 million threshold for DoD IDIQs, irrespective of the agency actually awarding the task order. That's sort of a summation of those critical points. So that's when you're filing task order protests, you know where to go, you know how to do it, you understand all the nuances that apply, and that's on top of all the timeliness issues and the debriefing questions and everything else that we already went through. What if, though, you were procuring something, or you were bidding on something rather, through a joint venture? Okay. Well, when you're dealing with a joint venture, how do you file a protest? I've had this question come up a lot. Like, can the managing member file a protest? Can the minority member file a protest? Or any of the members of the JV? Can any of them file a protest? Who is the protest filed on behalf of? Is it on behalf of the joint venture? Is it on behalf of the members? What if the joint venture isn't a separate LLC? What if the joint venture is a partnership? Okay, well, how does that file? Well, you didn't, it's just a joint venture by contract. You never formed an entity. Then who files? Well, when you're dealing with that, first and foremost, you have to look at your operating agreement. If it's a separate LLC, you should have an operating agreement. What does that say? That's going to matter. Does it say that only the managing member rather can file a protest? If so, that's who has to file it. Otherwise, no one else has authority under the operating agreement to do that. If it's a JV by contract and you didn't really form a separate LLC, there is no operating agreement. Well, what about the JV agreement itself? Do you have some sort of JV agreement? What does that say? You have to look at that. Okay. If that, even if I should say, that says one thing or another from like a legal perspective between the parties as to who has to file, who has authority to file, it has to be filed on behalf of the entity that submitted the proposal. So if you have a separate joint venture that is a separate LLC, only that separate LLC has standing to protest because the members themselves didn't submit proposals. Right? Or it was only the joint venture that did it. If proposals haven't been submitted yet and you plan to submit on behalf of the joint venture, let's say it's an 8A set aside. Well, the joint venture might be 8A compliant because the managing member is 8A compliant, so therefore the JV takes on that identity. But let's say it's a mentor protege. The mentor is a large business, or at least not 8A, and the protege is 8A. Well, in that case, the government doesn't know who's going to submit the bid yet because it hasn't happened. You're filing a pre-bid protest. In that case, the 8A company could file a protest of its own, or the joint venture could file it in its name. Either one of those is okay because you haven't submitted a proposal yet, so both of those parties are eligible and have standing to theoretically submit a proposal. The mentor, however, is a large business and does not qualify in this example, and does not qualify as 8A. So in that case, the mentor cannot file because it doesn't have standing to file. You have to be an interested party to file a protest. And only parties that are eligible to submit proposals and win the award are actually eligible and only have standing. So in that scenario, the protege and the JV have standing, the mentor doesn't. Once you've submitted the proposal, though, it has to go by the party that submitted the proposal. If you have a JV by contract, and let's say you're using some sort of trade name or DBA or whatever, once you've created a JV by contract, by most state laws, you've created a general partnership, technically. So it's a separate partnership entity. You might have given a name, you might not have given a name, but if you submitted that proposal as the partnership, it's technically that partnership that would be submitting the protest in that particular instance. JVs by contract have a lot of other issues and there can be other problems with it. We don't generally recommend it, but if you go that route, that's some of the things that you're going to have to deal with. If you file a protest, and let's say it's an 8A or a serviceable event or woman-owned or something like that, and that's what the JV is. If that protest is filed on behalf of or signed by the mentor company, let's say it's a large business, they're not qualified, that can be a problem. Someone could try to say that wasn't filed appropriately or with appropriate authorization, and therefore the protest should just be dismissed entirely. So you're going to want to make sure that you're crossing all your I's, crossing your T's, dotting your I's rather, and that you're doing it all appropriately. So in that case, make sure the 8A managing venturer is the one who's signing things or submitting things. Or if you have a declaration that you need, it's a general declaration, it's probably better to come from them. If you're using counsel, then it would be the lawyers submitting it. But you want to make sure they're submitting on behalf of the JV, not that they're submitting it on behalf of any of the members, especially if it's post-award and the JV submitted the proposal. That protest better be filed by the actual JV entity. So if you're on a JV, let's say you're one of the members, say you're the managing member, and you call your lawyer and you don't tell them, you're like, we submitted a proposal and we have this issue, we need you to protest. The lawyer should be asking you for all the proposal documents and everything else to be clear who that party is. But if they end up filing something under your name and the JV submitted the proposal, that protest is likely going to be dismissed. And by that time, you probably can't refile it. So you need to make sure that you're filing it with the correct entity. In the JV, file it in the name of the JV. Make sure that you have some sort of authorization if the JV document requires that the managing member approve any sort of protest filing or any sort of initiation of litigation, or if it says both parties have to do it, make sure you go through that step so that you have the appropriate approvals under the agreement itself to make sure that there's clear authorization to file. So if someone tries to claim that the protest wasn't filed appropriately, you have that document to paper the record to back that up. That's also important. So that's some of the nuances there with joint ventures and who's filing and when to file and all that kind of stuff. What about taking a step? So we've gone through task orders. We've gone through like, well, what if I'm a joint venture? What are the nuances there? What if you've already filed a protest and you've won? The agency has decided in response to your protest that they're going to take corrective action, something. They're going to do something that's going to, in their mind, alleviate the allegations or the issues that were raised in the protest. But let's say you don't agree with that. You think what the agency did doesn't actually correct that issue. So you have a problem with the corrective action. It doesn't go far enough, or it's completely off base, or it doesn't hit every issue that you raised. They're just going to take some sort of corrective action, and you want to challenge that. You cannot wait to challenge that corrective action until like later on in the process. Okay, you have to file the protest on that corrective action piece within 10 days of when you knew or should have known of the corrective action. Also, if you have a protest pending at GAO, you could attempt to file a supplemental protest under that same what they call B number, which is the case number at GAO. You could attempt to file another corrective action protest or a supplemental protest. However, if the agency takes corrective action, GAO will generally dismiss the protest in short order. If they do that, and you want to challenge the corrective action, you have to file a new protest. It's not sort of a supplement or an add-on to an old protest. And that's generally true. You're going to have to file another protest later to challenge the corrective action. If there's a situation with the corrective action that has been filed that you believe that the Court of Federal Claims, you're at the Court of Federal Claims, let's say you're not a GAO, and the agency takes corrective action, there you actually can ask for a hearing or file motions. You have more freedom into exactly how you're going to do it before you end up having to file a new protest. You could say, no, we're not agreeing to that corrective action, or we don't think that corrective action actually addresses all the issues. So while it might address issue 1, it doesn't address issue 2, 3, and 4. And you could go to the judge and see if they'll agree with you. And if they do, that protest might stay alive and go through the rest of that while you're challenging those other issues. Another thing I would recommend is if you're not happy with the corrective action, have your counsel, or you could do it if you filed the protest, talk to the agency, right? You don't have to jump right into filing a new protest. You can talk to the agency about the corrective action issues and how to make it better and how to fix things. We just did that in a couple cases where the initial corrective action wasn't good. We talked to them, they revised it. We still weren't happy. We talked to them again, they revised it again, because the agency doesn't want to get caught in this flurry of protests over and over, and you don't want to have to go through the time and expense and frustration of filing a bunch of protests over and over. So if you can avoid that, go through that process. Another thing to note when you're dealing with corrective action is that the lack of agency action could also be deemed to determine to be a negative action taken towards you that kicks off some process. So if the agency doesn't take, if they're in the process of taking corrective action, they don't do anything, and it's been 4 months, okay? That might not be enough time yet to deem that the agency hasn't done anything. If it's been 6 months, that's a better argument. If it's been a year, probably you're good, right? You could say the agency hasn't done anything, we're filing a protest. But if you're waiting for corrective action, it's been 2 weeks, and you're upset the agency hasn't done anything, or come out with a new solicitation or done whatever it is they're going to do, and you want to fight that because the agency's not working fast enough. Yeah, that's not enough time. Like having just a couple weeks, even like a month, is not reasonable in the eyes of GAO, the Court of Federal Claims. Like generally, agencies are allowed to take months in order to do something. If it turns out the agency was purposefully slow rolling something to harm you, in that kind of circumstance, you might be able to file something and challenge it on that basis as well, and not necessarily wait that 6 month or year period or whatever it happens to be. But you just need to know that corrective action can take a while. Another thing I want to note on going to some of the timeliness issues is another kind of trap that we've seen recently. If you file an agency level protest before you submit your proposal, and you file it, it's clearly timely, you submit something. And let's say what you're asking for in that protest is for the agency to revise the RFP, set a new date because of whatever ambiguity or issue you found, and you're filing that before, you're waiting for them to take that corrective action. The date and time set for submission of proposals has passed. So you've already filed your protest, so you filed it 3 days before bids were due. You did that. The agency still accepted proposals, okay? There's a new GAO case that said once the agency accepts proposals, you should know that they've denied your protest from, in this example, 3 days ago. Because had they agreed with your protest grounds, they would never have accepted proposals. That's what GAO said. I don't really agree with that because a lot of times that maybe it's not enough time. Maybe the lawyers are on vacation or something. The agency has to wait for them to get back from vacation and then talk to them, but they didn't want to slow the procurement process, okay? However, because that case exists, you need to know that the lack of corrective action taken in response to your agency level protest, the lack of corrective action prior to accepting proposals means that that acceptance of proposals is a deemed denial of your protest, and you have 10 days from that date to go to GAO. If you wait because you're waiting for a formal response from the agency and they send you something 11 or 12 days later, you are now outside the window, arguably, to go to GAO under this line of cases. And therefore, you'd have to go to the Court of Federal Claims. If it is a task order that's above the threshold that we talked about before in the earlier in this session, we talked about the $10 million and $25 million thresholds. If it's above those thresholds, you have to go to GAO. So if you got your proposal or your protest submitted to the agency prior to submission of proposals, they accepted proposals, which can be considered a deemed denial. They've given you the response to that protest on day 11 or day 12. You might now be untimely to file at GAO because it's more than 10 days after you knew or should have known of the denial, meaning when the agency accepted proposals. And you cannot go to the Court of Federal Claims because it's a task order, and GAO has exclusive jurisdiction over task orders. So in that case, all you can do then, you could try to file GAO and make some arguments as to why, and I could see some arguments, I could think of some, as to why you would be timely. But you still have a risk there because you waited more than the 10-day period after you knew or should have known. You can't go to you can't go to the Court of Federal Claims rather because of that threshold of the 10 million, 25 million. The FASA bar says even if it's above that threshold, you can only go to GAO on a task order. You can't go to the Court of Federal Claims. So you're stuck, and you might have nowhere to protest. You might have to just complain to the ombudsman, or again, shout at the heavens or pound the table and walk angrily back and forth in your office because you waited too long. And remember, these are all calendar days, not business days. Doesn't matter if there's weekends or holidays or whatever. It doesn't matter if it's over winter break or anything like that. These are hard and fast rules, hard and fast deadlines, and these sort of traps you can find yourself in can make it so that you're completely out of luck if you just wait an extra day or two, or you don't know, you're not tracking these things as specifically as you need to, and you can end up losing your rights. So hopefully this was helpful, these past 3 sessions on kind of tips and tricks and traps dealing with bid protests at all different areas, all different levels, and that now you're equipped to know a little bit more and to understand your rights and how to keep things going and keep the government honest. So thank you again. I appreciate it.
For joining the PCI Practical Matters podcast. We'll return with another topic in a few weeks.